in the US, once a private antitrust plaintiff successfully proves the fact of its injury, it faces a less stringent standard in establishing the amount of damages or harm. A jury may make a just and reasonable estimate of the damage based on relevant data, so long as it is not based upon speculation or guesswork. In Europe, our courts also face significant difficulties in regard to quantification of the harm and determination of the damages. We know that the European Commission is preparing an unbinding guidance for national courts based on the Oxera study on quantification of damages in antitrust cases, and we expect this guidance to be released sooner or later this year. On the issue of fault, I can say that under EU's law, fault is not an issue, and the fault doesn't have to be proved. There is no fault element under EU law. The European Commission is suggesting in white paper as well a liability on no fault. I would like to go to the few procedural issues which are very relevant and where there are significant differences among US and EU law, and this is a discovery or access to file. We know that private enforcement requires access to non-public information, and much of these data are likely to be in possession of the plaintiff. And the problems associated with obtaining evidence may be minimal if the government's establishment of liability can be relied upon during the remedy proceeding. If not, or if stand-alone litigation is permitted, then the need for some form of discovery is far greater, or even essential. The policy question is how to balance the claimant's need for information against the defendant's legitimate concerns about confidentiality and the legal system's need for limiting the scope and expense of litigation. As we know, in the US, the system is known as discovery. It has been authorized by the Federal Rules of Civil Procedure, and it has a broad scope. The courts apply the test of reasonableness and standard of relevance. The courts can limit discovery requests when burden and expense imposed outweigh prospective benefits of the requested information. Outside the US, there is a big skepticism about the costs of American style of discovery. But in this regard, I would like to observe that the fishing expeditions are not permitted by American courts, and that the judicial intervention in the discovery process is common, even though the process depends heavily on private initiatives. Access to file in Europe is still a very open issue, and we had the chance to hear today about the recent decision of the Court of Justice on Fleiderer versus Bundeskartellamt, tackling the issue of the discovery of leniency applications, where the Court of Justice, just to be very short, took a rather neutral position in regard this question, not following the opinion or of the Advocate General, and saying that it should be a discretion of the national courts to weigh the interest of leniency applicants and the interest of claimants and plaintiffs. Another procedural issue, which is of much of relevance in antitrust cases because of their obviously special nature, is the role of experts, which we know because we know that antitrust litigation relies heavily on economic theory. Therefore, the economic experts are used to establish various elements of a damages claim, like a market definition, antitrust injury, or damages calculation. In the US, the question of the role of experts has been, in a way, defined by the decision Doppler versus Merle Dow Pharmaceuticals, where, following which experts' testimony is allowed under the conditions that expert has sufficient specialized knowledge and expertise, the methodology and data used are sufficiently reliable, and the expert's testimony is sufficiently relevant to assist trial of fact. In Europe, there is a big difference. There is a big difference because we don't have party-appointed experts. The experts in our proceedings are appointed by the court. Therefore, their role is a different one than their role is under the US proceedings. This leads me to remedies, which we know there is a focus on damages, obviously in the US, treble damages. Section 4 of the Clayton Act allows private plaintiffs to recover treble their actual damages along with costs and attorney's fees. Other damages available are obviously injunctive relief and which couldn't be a declaratory and preliminary injunction. We know that there is a question whether we should permit joint and several liability, and under US law, courts traditionally impose liability on a joint and several basis upon any defendants found liable under the antitrust laws. Defendants who have been accepted into the criminal amnesty program of the Antitrust Division have agreed to provide assistance to plaintiff in a civil action may be excused from joint and several liability. When the related issue of whether there was a right of contribution among antitrust co-defendants reached the Supreme Court in 1981, the court says no, there is no right to contribution. In Europe, in most member states, a right to contribution does exist, and it is most relevant regarding co-defendants. It is currently an issue of intense debate whether contribution claims against leniency applicants should form an exception in order to build additional incentives for leniency applicants into the rules on private enforcement. Antitrust immunity and damages actions are obviously closely related issues, and the issue have been resolved under the US law in the Antitrust Criminal Penalty Enhancement and Reform Act of 2004, which limits the civil liability for amnesty applicants. In any civil action where the plaintiff alleges of a violation of the Sherman Act or a similar state law, the civil liability of defendants granted immunity is limited to the actual rather than treble damages. Defendant is required to provide a full accounting of relevant facts, all relevant documents, and participate in interviews and deposition reasonably requested by the plaintiff. And finally, I would like to tackle an issue of challenging of funding a case. So how can cost rules facilitate access to courts for civil damages claims? So we know that antitrust cases are costly and time-consuming. The cost and time is virtually the same whether the case is brought by a single entity or a collection of entities. If we are to encourage collective redress and redress for end consumers and introduce the collective claims, there is a question whether a loser pays rules we have in Europe is a mechanism which will provide incentives for claimants to use class action mechanism. Under the US law, there is a model of contingency fees utilized by the US lawyers under which attorneys advance the cost of litigation and do not get paid for their times unless there is a victory or damages award, in which case they will be paid a percentage of the award plus their fees, with the funds coming obviously from the losing party. Litigation in the US, including antitrust litigation, may be funded by third parties. We know that there are significant developments in Europe as well, and in some of European countries there are also possibilities for at least limited contingency fees and funding of case by third parties. I would like to conclude that a purpose of competition law and policy is no longer the protection of market structure. Competition law is now strongly guided by result-based ideas of market performance and efficiency. Modern competition law sees consumer welfare as its primary goal. Thus, the consumer is given the right to defend himself against negative effects of competition constraints by means of private enforcement.
Bojana, for the very detailed comparison between the two systems, and Lars will continue.